Well, welcome everyone to the Zoning Board of Appeals meeting for July 28th, 2026. I'd like to introduce our board members. Online, we have Hunter Mathia. To my right, we have Corey Whiteside. To my left, we have our former chair, Tony Frankelange.
Yeah.
And now vice chair, and I am Michael Simonetta, the new chair. What we're going to do here, just to give you guys a brief overview. So we follow an agenda with a public hearing for each item during the first part of the meeting. This is the time for all information to be presented. When it is, for each item, we'll begin with the presentation by the applicant. They'll come up to the podium, sign in, and at that point, present their case. Then the public is invited to speak, to ask questions, followed by staff comments. Once the public hearing part is closed, no new information can be presented at that time. So in favor or against, we would need to hear it during the new part of the meeting. The regular meeting will follow. This is strictly for ZBA members to discuss and vote on the item. And again, legally, no new information can be presented at the time. And as I said earlier, a vote of 4 in favor is required for the variance to be approved. If there's more, obviously a majority. For this public meeting, all are invited to stay. However, after the public hearing part is over with, you can leave and Paulie and his staff can contact you the following business day. As each item is open, applicants are asked to sign in, proceed to the podium to state their name and provide the description of the request, including the hardship and reason for the work. Please note the meeting is recorded, so please use the microphone and speak clearly. Let's see what we got here today.
So to note that we have our fifth member joining.
Oh, who joined us? Oh, and our fifth member is Christine Mazzata. Hi, Christine.
Hello.
Mm-hmm.
All right, we will start. ZBA 2026-11, 6 Sawmill Drive, map 21-4, block 118, lot 5. William and Sons Builders, represented by William Hesbach, is requesting a variance of the Town of Berlin zoning regulation V.A.10 to allow a 26 feet by 24 feet home addition to be located 26 feet from the property line where 40 feet is required and 18 feet from the side yard where 25 feet is required in an R21 zone. The property is owned by Theodore A. Jr. Kaplan and Armin R. Kaplan. Speaking? Yep. Yeah, you could pull it to gooseneck.
Hello, does that work?
Yep.
Hello, everybody. So I'm here today to talk about a project that we're doing, which is what we'd like to do, which is a 2-car garage off of an existing home where there was a existing garage that was old and far away from the home, hard to access during the snow. And they would like to remove that, which is already come down because of damage to the garage itself. And they would like to build this 2-car garage, making it a 3-bedroom home, which is a 2-bedroom home now. And the reason for the setbacks is the positioning of the property in the house. The only way we could actually add on is to go in this direction.
Holly, can you pull it up?
Yep. parts of it that we're asking for that actually encroach onto any kind of property line is small corners of the building. It's not any one full side. It's just about 4 feet on one corner here. So extend about 6 feet of the building, which would be on, and then the front part there, that's a full full on towards the road.
That clear enough, or should I zoom in more?
This is the White House, correct?
Yep, the one, yeah.
Yep.
I have a great view of it.
Low.
We showed last time.
And that's the garage that was taken down?
Yeah. Base of it had termite damage. Tree did, but we're.
Pretty much after the hearing we had last month. The only issue is what they were requesting didn't encompass the second variance that was needed. That was for side yard setback. So they came in, actually did it before the hearing, but we didn't have enough time to put it on the legal notice. They had that amendment done, we renoticed it so that it could be heard today and decided upon in this meeting.
Hunter, Christine, any questions from you guys online?
No questions from me.
Nope.
Corey?
No.
Tony, questions from you?
No, I'm good.
Staff comments?
No further comments, just mentioned.
Motion to close this public hearing?
Well, do we have to ask if there's anyone in?
Yes, you do.
Is there anyone here speaking in favor or opposed? Corey made a motion?
I did make a motion to close the hearing.
It looks like John has online, maybe make sure that he'll be online.
Okay. And
About that. Maybe just indicate to them that they need to either raise them or put a note in the chat.
okay.
Thank you.
Is there anyone online that is opposed or in favor?
Okay, so
Staff's not seeing any hands raised or any comments added into the chat.
Okay. Corey made a motion. All those in favor?
aye. Aye.
Aye.
All right. You can have a seat. Thank you. Our next item is a ZBA 2026-12, 41 Primrose Lane, map 9-3, block 54, lot 37E. Andrew J. Fowl is requesting variances for the town of Berlin zoning regulations V.A.10 to allow an expansion of a screen porch within the side yard setback and a front deck / porch addition to be located within the front yard setback as shown on submitted plans, where a side yard setback of 10 feet is required and a front yard setback of 35 feet is required in an R15 zone. Speaking for the applicant.
My name's Andrew Fowl, live at 41 Primrose Lane. The window is open, you could see the house through the trees. My house, the way it was built, there was a driveway going to, on this left side, and there was, so the stairs in the front go to the left. And then, for some reason, they stuck a garage on the right side, so it looks dumb, the stairs go to the left. So I wanted to cover that with a small deck, porch, and also a side porch. I have a screened-in small porch, but it's really small, and just wanted to extend it just to the end of the house. Part of the reason I want to put on a back room and a 3-car garage, my mom's elderly and it's hard for her to get in with the wheelchair. So right now I just have too many stairs, and even the side, it's tough for her to get in. So this way she'd be able to get in the new room and just be easier to take care of her. And of course, I'll demolish the old garage because it's actually out of zoning. I don't know if you could see on the map, but there's a part of it, when they built it, it's out of zoning, so. It's not my house. It's nicer. That's the plan there. You see the garage is on the right, but when the house was built in 63, put the stairs from the front going to the left because there used to be like a little driveway there. So I'm thinking going it back just a little and then put a 3-car garage to the right. Oh, that's it. So demolish the old garage because it's really very functional, and it just looks dumb the way that it's situated.
I have a street view.
Left or right? You on the right of this property?
Yeah, to the right. Yeah, I'm in the trees kind of.
Okay. Might not be able to see it.
Oh,
It's behind that shrub there.
right where that fire hydrant is.
Yeah, exactly.
That's cool, kid.
I've got a number of a good arborist if you need one.
I like trees. It's cooler in some. But of course, many will have to go down. Yeah, you can see. The brown.
So where's the existing garage right now?
It's to the right. You can't really see it. There's trees around, but it's small. The way they built it, it's out of zoning anyhow. I don't know how they put.
Well, there's a variance on this property from way back, right?
Yeah, 2008, I was gonna go put a second level on, and they approved it for the front. So it's kind of coming back for a very similar issue.
I'm trying to see, we can look at a GIS overview without.
See, the garage is that green part, I think.
So it's a detached garage.
Yes, there's this
There you go.
small
Oh, yeah.
driveway going there.
What's the building next to it?
It's like a shed. It's like a green, one of those sheds that you could put up or take down.
Quonset hut.
Sort of, yeah, yeah. That's gonna go too.
Going back to this, the original survey there, so. Current garage. Not a part of the variance ask. The original one is beyond the setback here, but the one they're proposing is within the setbacks back
Right,
here.
it's way back.
Well, the only items that we're looking at is here to the left, that screen porch addition,
Okay,
the the new front porch here.
got it.
Kind of fix that issue with the stairs going to the left to nowhere, basically.
So was the, is the original screen porch not varianced? Like, did we not have a variance for that one
That's,
already?
well, when they built it, it was out of variance. I don't know, they built it with the house or it came later.
Hmm.
Yeah, the only variance I could find is for, if you see here back on the survey, I'll
Yeah.
pull it back up. There's a corner of the house that extends into the front yard.
It's like a little piece in the front left side.
Right here. So you see the dashed line,
Yep,
that's the setback. Then right in the corner of it. Probably about 2-3 feet of the home that goes into the setback.
Hmm.
So we're not sure how at least the front porch or the side porch came about.
It was there when I bought it.
Yeah. I mean, it shows on the variance plan, so I'm not sure why it wasn't discussed. Couldn't find any record of it.
It's just like a wooden frame with a screen.
Yeah.
No, the garage, the 3-car garage is gonna be on the side of the house there,
In the
Back
back.
here. Yep.
in the back. And it's encroaching on the side yard setback?
No.
No,
Oh, the garage would be compliant.
yeah, it's
Proposed
the
location.
porch.
Just the two
Pull up
porches.
that other picture.
I'm sorry, I missed that.
Oh, that's okay. It's the porch.
In the front and on the side.
Yep.
That light dash line you see here, the gray one, that's
Oh, okay,
it's a
okay, yeah.
setback line, yep. The garage back here, then that, pretty much right to it on that side. But these additions here are over the lines.
When the previous variance was the 35. or the
Yep,
33.
front yard here.
Okay, I got you. Thanks.
Hunter, Christine, do you guys have any questions?
None from me. Seems pretty cut and dry.
Yeah, no, I kind of feel like we're micromanaging this poor gentleman, you know. No, I have no questions.
Not for me.
Corey, anything from you?
Not for me.
I'm all set.
Nothing from you, Tony?
Good.
Are there any comments in favor or opposed here or online?
I'll make a motion to approve the application.
Okay, Tony has made a motion to approve,
Motion to close the hearing.
close the hearing. Not
I'm
approve
sorry,
it,
close the
it.
hearing on the application.
Second,
All those in favor?
Aye.
I,
Aye.
You can have a seat.
Ladies.
All right, next item. ZBA 2026-13, 30 Linden Drive, map 26-1, block 74, lot 200. Alan and Rhiannon Solek are requesting a variance of the Town of Berlin zoning regulation VIII.I to allow a 28 feet by 36 feet garage addition to be located 22.5 feet from the side yard where 45 feet is required in the MR1 zone. Speaking for the applicant?
Alan and Rand Solik. Good evening, everyone. As he said, we are applying for a variance for garage. We have a growing family, young boys, a lot of bikes and power sports products hanging around. Just trying to clean up the existing garage a little bit. So it is going to be.
Lift the microphone, please.
Oh, sorry about that. Yeah, so we'd like to build a 28 by 36 garage. The hardship being that we'd like to use the existing driveway and the wetlands on the property makes it very difficult to build anything additional.
Polly, can you pull that up? So we're talking the garage right here.
Correct.
Let's see it.
Another line?
Yeah.
Oh, it's over here. Yeah, you know, that's,
And you don't have any proposed plans?
We supplied plans from the barnyard. Without having the variance in place, no one really wants to work with us. Specifics.
Well, I just want to address the issue of attachment to the house. So these plans don't show that consideration?
Correct. So they're not a contractor to do home improvements, so that would have to be an additional contractor that I hire to do that.
Is it your intention to do that?
Yes.
Because the addition is going to be more than one story, it's going to have a bonus room on top?
Correct. Yes, 1.5 stories.
But there's gonna be no access though on the second story. It's just gonna be a loft above the garage. Correct?
Yes, correct.
Are you guys tearing down the existing garage or is this
There's not an existing
Oh,
garage.
there's no, you have no garage.
Would be new build.
Oh,
How are you attaching it to the house?
Breezeway,
So how many feet is the breezeway?
7 feet.
Okay. All right, I got you now. Oh, yeah, I see it. I see a 7 in there somewhere.
Claire, can you pull up the other map and point? I'm having a hard time seeing where this garage is going.
Christine, bottom right in blue lettering that says 30, just below the house in pink.
So it's included in that pink outline?
No, the pink outline is the current house. Garage will be the blue area, and then there'll be a breezeway to make it connected.
It's forward from the house, and then it's almost, lined up, a straight line with the house in front of it, or behind
No,
it.
there is
Behind-
no house behind it.
But it's not even with the house, though. It's behind.
Correct.
Okay, so it's behind the house, and then
It's set back behind the house.
Trying to fix the screen share. It's taking a while.
got it.
Now, the breezeway is, the breezeway's not shown on there anyway, right? It's not there.
No, just the
Correct.
7
It
feet
is
from the
not there.
house and the covering will be there.
But are you gonna use a part of the garage depth for the breezeway?
No, it'll be roughly 4 feet long, 7 feet from the house.
Okay, I got you. I got you.
Yeah, okay. Yeah, sorry. Yeah,
7 feet from the house and 4 feet that way.
correct.
So you can just get out and go over there
Yes, correct.
and drop off shoes and whatever. Okay, mudroom,
Yes.
small mudroom. Right here, Mike. Right there,
yeah.
a little area.
Yep.
That's what was confusing me, but I got it now.
Well, I mean, it's so busy.
This is all one lot. All these dimensions on here drive you crazy, but I mean, it's all one lot. That's what it is.
Is it really?
Yeah, this is just, these are all just, they're lot lines, but they're not, it's all one lot.
Huh.
Looks like you built a house on 4 lots.
Interesting.
I know. All right.
Corey,
No further questions.
Tony,
Good.
staff comments.
Now I don't understand it.
The only comments from staff are just referencing the breezeway again. So you are allowed to go above 15 feet with a accessory structure as long as it's attached.
Yeah.
So the breezeway requirement allows that to exceed 15 feet. They're proposing. So if board were to approve, we would just have a condition that whatever plans were submitted with it will have to show the breezeway there.
Okay.
Okay.
Are there comments in favor or opposed? Either present or online? If there's no other comments, I'd like to make a motion to close.
One go back.
Okay.
Polly, I cannot find a reference for MR1 as a zone. What is that?
Mountain Reserve,
On reserve, yep.
it's where I live, same one.
Oh, yeah, Mount Reserve.
Okay.
Oh, special use zones? Is that's where it is? Yes, sorry about that. Okay, go ahead. Proceed. Motion on the table?
I'll make a motion to close. this
I'll
hearing.
second.
All those in favor?
Aye.
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 Close. Please step down.
Thank you.
Next item, ZBA 2026-14, 224 Berlin Turnpike, map 4-4, block 82, lot 18-7715. Irana, I won't even try to pronounce the last name because I won't get it right. LLC is requesting an alcohol use location approval for a grocery beer liquor permit. The property is owned by 224 Berlin Turnpike LLC and is located in the PS-B zone. Speaking for the applicant?
Hi, everybody. My name is Irina Kobylanska. I know it's a little tricky. We actually have a Ukrainian European grocery store, but it just opened like a year ago on the Berlin Turnpike, little big plaza. A lot of customers are asking about the beer, what if we can sell the beer. That's why we come in today to take the permission to sell, to have little area to sell the beer. And we have a lot of food actually. What we just sell it like handmade food, frozen food, what actually people can buy and prepare at home. We sell a lot of beverage, milk, and a lot of snacks and candies. And we just want to add little area with the beer.
Where is this location?
224 Berlin Turnpike, close to Acura dealership.
Yeah, right across from the Home Depot Plaza.
Oh, okay.
Next to Faux and the old Boss Grill building.
Oh, okay.
What, you have did you apply for a liquor permit with the state?
Before to apply for the state, we need to have approved from the town hall first.
But then you have to apply to the state too, right? Okay, so you're aware of that? Oh, right, okay.
Hunter, Christine, any questions from you guys online?
None from me.
Nope.
Tony?
I don't have any questions.
None.
Court?
Oh, this is the one.
Staff comments?
Okay. Well, have you got a GPS location for that? On the map?
The street view, or
Yeah.
I can pull that up, yeah.
I'm trying to find it. It's okay, I got that. I'm not with it.
Just to comment on one thing that we were looking at and discussing, that other zones specifically list alcoholic beverages sales. Then Attorney Capola pointed out that we don't see that exactly here in the PSB. But I know we did grant approval for a few of the restaurants here pretty much in the past few years, getting that. That's something we would have to look into as well.
That is fancy social restaurant there.
Yeah.
It's a fancy social restaurant there.
The Fancy Sushi, yeah, it's the other one.
So that, just for the record, Jennifer Capola, so that is mentioned in the staff report, is that there is a restaurant that does have a liquor permit in the same building. But I just noted as I was looking that in other districts, like in the Berlin Turnpike, other districts for the Turnpike, that you have as a special permit the ability to grant, and it specifically conveys authority to your board to grant. So it may be, again, that as staff pointed out in their staff report, that it's coming in under the restaurant use, recognizing that that's a restaurant permit, and whether you treat this as a retail use because it's a grocery beer permit that's being sought. But it may be something, Paul, that we want to have the commission add, I think, just so that they're not facing this specifically without that language being in there. And you thought there was another business as well that was granted?
Yeah, I believe the burger place had it as well.
Well, but they're gone.
Prior to that, they've had the beer or the on premises liquor.
It goes with the
permit,
business
all that.
though.
What's that?
The permit goes with the business, not the property.
Yeah,
Right.
then the next business that came in was Fancy Sushi in that same location. And they were granted same
Yeah,
approval.
yeah.
Well, either way, we're distinguishing between liquor, restaurant liquor, and grocery beer.
Beer, exactly.
It's two separate permit types,
Mhm.
right?
We're looking more in terms of the overall alcoholic beverages sales location approval that ZBA has authority to grant. That's the question that we're with.
So in this instance, you'd be considering it under the first permitted use of retail
Mhm.
sales. Which it appears was used for the existing sushi restaurant in the prior.
But are you drawing a conclusion on the application? Is the application not filled out completely? What we are approving is the application, correct?
I think the issue is that, this isn't a non-premise consumption. I mean, it sounds like, may have had other liquor sale, circumstances where, it's been approved because pursuant to the statute and the treatment of these types of applications, this is something that is within your authority as a special certificate of location. So it is appropriately before you. And if but I would confirm.
Yeah, the issue is she brought up that other sections do explicitly outline a separate
As a special.
alcoholic beverage.
As a special permit use. And, designate your board.
Similar to the.
I'm not following.
Similar to the automotive uses location approval that
Mhm.
used to be under your jurisdiction. Some sections would have a separate special permit granted by ZBA that would mention that. So the regs also have that for alcoholic beverages location approval. Some sections do have that. But I know I think generally the policy has been to grant it to restaurants because I know at least in the CC 1 and 2 zone, it's also not allowed there. But most of the restaurants that have been established have gotten the on-premises liquor permit, on-premises consumption.
So just for example, I just went to your general commercial, you know, each district, obviously it sets forth first the purpose, and then typically there's permitted uses or special permit uses. The general commercial, it sets forth purpose first, site plan uses, and then special permit uses. And it does indicate under special permit uses ZBA, it's in subsection 4 of that general commercial. This is on the top of page 76 if you have your regs open.
I have it screen shared as well.
It specifically says the following principal uses shall be permitted in the GC district subject to special permit approval by the ZBA in accordance with section 12, and then subsection B there says liquor sales. So it's conveying to your board specifically the ability to approve the liquor sales in the general commercial district, subject to special permit. And you see that in other districts as well. Like that, as I was scrolling through, it's in the one of your Berlin Turnpike districts as well, but not specifically in the district, again, the PSB district that this property is in at 224 Berlin Turnpike.
I'm also looking up that.
So it seems like it's just maybe a whole.
I'm looking at the other section here with that section 11B, sale of alcoholic beverages.
Sure.
That just states all places where alcoholic beverages are sold, or dispensed for consumption on premises or off premises, unless otherwise stated in these regulations, shall be subject to location approval by the zoning board of appeals.
And that, I mean, that's statutory.
Yeah.
Which is why, again, it's appropriately before the determination, and you do have they do have
Yes.
the authority conveyed, like in the BT2, it's in there as a special permit use assigned specifically to you as well. Similar language to what I just read from general commercial. So I think it's fine. I think it's a top, you probably want to.
Something to button up, yeah. I brought up also the CCD2 zone. That's a zone where maybe by policy, we've been approving that for a number of years.
Yeah.
But there's also not indication of that alcoholic beverages sales approval granted by ZBA here. But we've done it. It's been to the board. That's it.
So you're saying it's an incompleteness in the zoning board regulations? Or the zoning regulations?
Possibly it's something that we would have to button up a bit, make sure it's consistent all around.
But by historical practice, we have approved these applications.
By state statutory authority.
Okay, so if there's no recommendation to table this from council or any other comment like that, then we should go forward. Motion still on table to close the hearing?
Well, we have to ask if there's comments in favor or opposed before we can close it.
I'll note that there aren't any other participants online at the moment.
Anyone in attendance, comments, favor or oppose?
You turn your mic on?
Yeah, my mic's on.
You got it on.
Anything else from staff, council?
No, I just wanted to point that out to you, that distinction. So yes, so you would be acting under retail sales in this circumstance.
I'll make a motion to close the hearing on the application.
Second?
All those in favor?
Aye.
May sit
Aye.
down. Thank you. ZBA 2026-15, 363 Lower Lane, map 15-2, block 102, lot 77A, Arthur and Cheryl Voles. are requesting a variance of the Town of Berlin zoning regulations V.B.5 to allow a subdivision and a building lot to be created with a frontage and a width of 50 feet from their existing property where 75 feet is required in an R11 zone. Speaking for the applicant?
Arthur Volt.
Go ahead, sir.
We built our original house in 1985. The original lot was 100 by 200. In 1996, I acquired the rest of the land, making it 125 wide by roughly 600 and I don't remember the exact number deep. With the intention of it someday we might be able to build in the back or let one of my children build in the back. Well, as time has gone on, we want to build in the back, except we want to sell our existing house to one of our children and build a retirement home in the back, a little smaller than what we have now in one level. Being as we have 125 feet, we're requesting a sideline variance to go 50 feet, and that would be to put a driveway to the rear where we have roughly another acre to build smaller home, like a ranch type home on that lot. I have been presented with a piece that said frontage requirements, typically a minimum of 75 feet of frontage for a standard building lot. Variances are sometimes requested if down to 50 feet. It was also noted in the thing that my brother does live next door. He bought the existing house off the family when my mother passed away. I don't wish to approach my brother to buy 25 more feet, which I was told I could buy 25 feet and it could taper into the existing 50 feet I have, and that would give me my 75 feet. But it would, instead of him having a nice square lot, it would totally alter his lot, which I just don't feel is necessary.
Like,
Can you pull up the image?
yeah, please.
Was there a variance on this years ago?
No, I didn't find any history of a variance here in this property.
No?
No, not on this. That good, or should I zoom in more?
No, that's good. Would it be a shared driveway? Or would it be a separate?
It would be a separate driveway.
Okay. Oh, okay, I see. So then a new driveway would be coming to the top there where the two pine trees are
Yes,
to go to the back of the property?
yes.
So would he be needing a variance for that as well too, since the driveway is going to be so close to the property line?
You mean for,
For
Driveway
the, for the
setback?
new driveway, yeah.
we don't have any setback requirements for pervious surface in terms of driveway pavement.
Okay.
Residential property.
After the board, Jennifer Capola, for the record, after the board asks any questions that they would like, I would like to address the board with regard to the use variance. It is not something that you regularly see, and I do want to give you some guidance on it.
Yes, please. Yeah, I mean,
Let
maybe
you
we
ask
should
your
start there with jurisdiction. I mean, I felt like the biggest issue with this case was whether we even should be hearing it for jurisdictional purposes, based on what, staff comments brought to the table. So perhaps that's where we should start anyway.
Is that the desire of the board? Everybody on the board, would anybody else? like
Yes,
to add?
please.
Go ahead.
So, just with regard to use variances, we talk about your variance authority being something that should be sparingly exercised, and I think, this board is well familiar. I know all of you are very seasoned board members, and you're very familiar with what the variance requirements are, both statutorily and in your regulations as well. So there's of course the hardship analysis, but with use variances, we kind of start elsewhere. Because there is a portion of the statute that conveys your authority that says, and I'm gonna read the language to you, and it's gonna come back to some of you because we've had a couple of cases through the years involving use variances that I've litigated for you. But the statute in question is section 8-6. It's the powers and duties of the Board of Appeals statute. And it conveys in subsection A the powers and duties that you have pursuant to state statute and also your regulations, which reaffirm the statutory language. But it says at the end, provided that the zoning regulations may specify the extent to which uses shall not be permitted by variance in districts in which such uses are not otherwise allowed. So it sets forth, and I'm speaking to subsection A3, it's at the end of that sentence. Again, in Connecticut General Statutes 8-6, it sets forth the various variance requirements, but then it says that your zoning regulations may specify the extent to which uses shall not be permitted by variance in districts in which such uses are not otherwise allowed. So that's been interpreted in case law, of course, as having sort of the obligation placed upon the Planning and Zoning Commission to, in the zoning regulations, identify those parameters of when use variances can be granted. And you see different types of regulations in this regard. There are some towns that actually require a referral to planning and zoning before ZBA takes up the use variance. You don't have that in your regulations, but you have other sections of your regulations that show compliance, and certainly in your zoning board of appeals section, which is section 15 of the zoning regulations. But even before then, in section 4 of your zoning regulations, which is the application of zoning regulations section, in the general provisions in subsection 3, it says determination of uses where a proposed use is not clearly permitted nor clearly prohibited in a zoning district by these regulations. The commission shall make the determination as to whether the proposed use is permitted in that district by right or by special permit or is prohibited. So when we know if you had something that wasn't clear, that it is supposed to go to the Planning and Zoning Commission, because they are zoning commission, but they are a planning commission, right? So we talk about the planning and zoning commission as having planning authority. So that's why they're sort of initially controlling this area of use variance, right? Because they have a planning authority. So, you know, we talk about, you know, the zoning board of appeals um, certainly having very clear authority to vary, but also not being the planning authority, right? So in your section of the zoning regulations, the zoning board of appeals section, again at section 15, A4, this is your A is your powers and duties section. A4 use variances, it says there's an A, B, and C subsection in subsection 4 or subpart A, B, and C. It says no use variance shall be granted by the ZBA, which would permit one, a use prohibited either implicitly or explicitly by these regulations. Two, the expansion of a nonconforming use. Three, the number of dwelling units on a lot to exceed the maximum allowed in the zone in which the lot is located. Or four, a use otherwise allowed by special permit in the zone in which the use is located. Okay, so if it's a use prohibited either implicitly or explicitly by the regulations, a use variance shall not be granted by the ZBA. Okay. So you have an issue here, and the staff report reflects this, that the applicant came in and initially was going to ask for, it sounds like, for variance of the regulation that disallows rear lots in this district and is not presently pursuing that tonight. Okay, so there's a couple of things about this. First of all, he would not be able to, in fact, create a rear lot unless he were to get a variance of that zoning regulation. And more specifically, what am I talking about? I'm talking about section 5, which is your residential zone section. B, single and two-family residential for R11 and R7. This property is in the R11 district. Subsection 3 there. So again, section 5B3. So special permit uses. The following principal uses shall be permitted in R11 and R7 residential districts, except as noted, subject to special permit and site plan approvals by the applicable commission in accordance with section 12 special permits and section 13 site plans. A, all uses permitted in the R86, R43, R21, and R15 districts subject to special permit and site plan approval as indicated in sections 5A3 and 5A4, except for rear lots, OSFs, DOSDs, and wineries, which are not permitted. So for this zoning district, R11, pursuant to section 5B3A, rear lots are not allowed in R11 zones. Okay. So again, going back very clearly, section 15A4 indicates that no use variance shall be granted by the ZBA, which would permit one, a use prohibited either implicitly or explicitly by these regulations. Rear lot is explicitly prohibited. And again, going back, that's not before you because they've chosen not to ask for that, but they do need that. They need a variance to be able to do. He's telling you what he wants to do. He wants to create a rear lot. And more broadly, too, you also do not have the power to subdivide. That is a power that rests solely with the Planning and Zoning Commission.
I've
So
been on this commission for about 27 years, and we've had several instances where they requests come in to subdivide, and none of them ever approved. None of them. And we don't have the power to do that.
No.
basically. They told us we don't have the power to do that. So I don't know why this application came to us to begin with.
So this should have gone to planning and zoning first.
So I will say this, I mean, one option and, you know, staff, I know, you know, does try to guide. There's always the opportunity, to try to get planning and zoning to amend the regs to allow rear lots. Rear lots are allowed in other residential districts, but, they specifically made a choice to disallow them in R11 and R7 when they passed the regulation that I've referenced. So I think you got to be careful here because ultimately, and I wanted to listen closely to hear and give the applicant an opportunity, of course, to present, you know, what his desire is. And he didn't speak specifically to hardship either. That's another component of this. Even if it were, of course, allowed, you would still have to make that hardship finding required by statute, required by your regulations. But his desire here, he's been very candid with you about what he's looking to do. And this amounts to an attempt, you know, to subdivide with the intent of creating a rear lot, as he's indicated, to use for retirement purposes. But this is not the avenue. Starting with you is not the avenue.
I
So
have a
that-
question.
I
Is
advise-
he allowed to put a second building on that lot without subdividing?
Second residence?
Second, a second without subdividing, with it remaining one lot.
Addition,
Oh, you-
addition.
Yeah, you can't have two residences. You can have an accessory structure, but not two primary residences.
Ms. Mazzata, did you hear the response from Mr. Morbidelli? There cannot be two residential structures on one lot. That is not allowed
In R11.
in any residential district.
Okay.
I would like to ask one question as to why we would have a board in this town that can't represent all the residents. And clearly you're being told you can't represent me,
I don't see it that way, Mr. Bowles.
okay?
I'm not sure if maybe I don't understand your question.
Well, evidently your board, from what the attorney just said, can't act on my variance.
It's a jurisdictional issue. The jurisdiction of this board is very specifically proscribed.
But you can't actively allow anything in an R11 zone with your board, according to what she just said.
Mm.
You can't grant what I want to do, I guess.
Well, we're discussing that. I think
Okay.
we haven't come to that conclusion, but I mean, related to your comment, Attorney Capola, did you say that the Planning and Zoning Commission itself would have the capability to grant the variance to the use?
Well, it wouldn't be a variance because they do not have authority to vary the
They'd
regulation.
have to actually modify the zoning to approve to consider his application for a subdivision.
I mean, that is one path that he would be able to take, would be to propose a text amendment to eliminate the prohibition. But without that, I mean, there's a direct prohibition. And for you to ignore the fact that he's not asked either for a variance of the rear lot when he's told you very specifically that that's what he's intending to do. So there's the additional issue of the fact that his application is not complete. He's not seeking all the variances that he actually needs. He should be asking for a variance of that prohibition, but legally he's not entitled to that because what the Planning and Zoning Commission has done is they've passed regulations which they're pursuant to 8-6 and that portion of 8-6 that I read to you, that they have authority to, and I could read the language again to you, but they have authority to pass regulations that may prohibit uses. I'm paraphrasing in a very short way. So yeah, I mean, that's within their authority. And from a legal analysis, I don't think they're overstepping at all. They clearly made the decision that they were going to allow rear lots in certain zones and not others.
Well, the variance in the application, it seems to me as, it's like a non sequitur. It's like he's asking for a frontage variance when there's no use for that frontage. And so even if we go with the chicken or the egg, it's like sometimes we have cases here that planning and zoning needs to know that a variance could be considered if they make their decision, and we need to know that the Planning and Zoning Commission will agree to something if we make our decision, and we can stipulate those things in our decision. But in this case, there's no reason for a frontage variance because there's no possible way that you can use that variance. That's the way I interpret it.
My interpretation is if we did something illegal and granted the variance, we'd have about 15 lawsuits on our hands.
Well, and this is the real answer to Mr. Bowles'
That's what
question.
happened. I mean, we
It's
had
why we can't decide
over a
something,
dozen of these in the last
because
27
we are an
years.
entity that can be sued.
None of them
by
were
the
ever approved.
applicant under the state regulations. So that's why we have a representation here.
Because it's more than the
right.
variance, it's the subdivision of the property.
Yeah. It's not our rule, it's the rule of the town. At R11, R15, it's got certain amount of frontage and that's it. And we can't change that. We haven't been able to change it for the last 20 some odd years. Like I said, we've had that situation show up about a dozen times and we couldn't do anything about it.
So this would be a case that planning and zoning should be hearing.
If the applicant desires to pursue a rear lot, one path that he has, and I'm not here to give him legal advice,
Of course.
but one path is to submit a text amendment to planning and zoning to see if they'll reconsider the prohibition that they have. The R11.
Yeah, but you might be sending the poor guy into a fire. I mean,
Well-
because I think another way to handle this is if you add onto your property, you got one lot and it's a little bit bigger, maybe you can put an addition on the house and take care of it that way. It's not two houses, it's only one house, but
But also at the same time, as he had mentioned, they wanted to build
a separate house.
a separate house, one level, and remain in Berlin.
Yeah.
And then that would have to be something that,
I don't think
planning and-
I don't think we have the power to do that.
well, obviously she said it, that's got to go through planning and zoning because they have to subdivide the property
Well,
more than
The
it's.
reason I brought it to you was because I was told in the zoning office that I was basically wasting my time because it wasn't going to get approved. That's why I decided to come to you guys.
Oh.
And I was later told that you have no jurisdiction in the R11 zone.
So wait, someone in the
That's
office.
why I said,
you were.
why do we have a board that can't represent all the residents of the town?
I'm curious as to why these two residential zones been isolated and, why this banning of the rear lots in these two zones, why that occurred in the first place. I'm curious to that.
That's not really a conversation for us or for tonight, though. And that's just what the regs are, and
The
that's
regs are.
not the parameters. We have to just stay within the parameters that are in the charter and in the town rules.
Yes. Oh, staff speaking, I did inform the applicant that trying to seek the use variance in this zone, something that the board does not have authority to do based off the regulations, only indicating that you can grant use variances in the GI and PI zones. That was a statement that staff did make.
So I guess this goes back to you, attorney. Since it is a matter of subdivision, because that's what they're trying to do is sub.
It's creation of a rear lot. I mean, I don't want to get too much into the weeds on this. I think you've got to deal with what's before you. We talk about subdivision. Subdivision is very specifically defined. And whether or not this constitutes subdivision, I'm not going to get into. That's not,
But is that something that should be presented to planning and zoning? Because obviously,
again,
and we want to do everything for the town properly. The last thing we want to do is say no to businesses, say no to residents. We're here to hear everything and make sure it's proper and done right. But at the same time, hearing what you're saying you want to do and understanding the law, because that's, the basis of everything is the law. And there'd be nothing, better, obviously, for your family or remaining on the property. My question to you again is, not saying this case is dead in the water, because obviously that's not a legal term and that's what attorneys don't like saying, but like, is this something that is better presented to planning and zoning for what they want to do rather than speaking to us about a variance of 50 feet where 75 feet is
Excuse me for
required?
interrupting. This is Cheryl Volz, Arthur's wife. I know the big question is, how are we zoned? And we are zoned in that specific area as one residence on the lot. I'm questioning two things. Number one, there's a duplex across the street from me that is two houses on one lot. How did that happen? And a couple more houses down the road is a multi-family home. How did that happen? Was the zoning changed for that? Because it seems like it was.
so I do not know what.
Well, I would like somebody, I don't want to hear, I don't know how. I want to hear why it happened.
I actually have some information that reflects when the R11 zone had been changed, allowing two families to only allowing single family house. We had another applicant asking that information for a different property. We were able to search that up and see the exact amendment date.
That was just,
I believe that the R11, Mr. Morbidelli, I believe that it does allow two-family homes currently. I will.
No, it
look.
does not.
I have the
Oh.
regulations. I will look. Have them open.
No, it was changed.
Give me a moment.
I have that here.
so was that changed for specific builders to come in and do certain things and then
Depends
change
on the time
back?
period. So I'll tell you the exact date where they removed it. So then if a property was built before that date, then you'll see that. So I have the date, so screenshot, I have it already. An applicant asked us, same question for another property. And here we have amendment dates for 2003. Then we have section 2B. The lighting. So here, section V, or section 5B, 2B, permitted uses. Amend to read as follows: two-family dwellings allowed in R7 zones only. But prior to 2003, they allowed two-family in R11. I have another document. We have the original document. This was prior to that. Yeah, so this was the original document before they amended it in 2003. The R11 and R7 zoning districts, permitted uses here are, see, the first one is single-family detached dwellings, and the second one is two-family dwellings. So 2003, that's when they removed the permitted use for two-family dwellings. Any property built before that, most likely compliant at the time. So I have to see the exact properties you're referencing to know dates they were built. Most likely they'll comply with the regulation here.
And if there is multifamily, there's a chance that it could be affordable as well. Again, not knowing what properties we're being asked to comment on, we can't give precise information.
But either way, it doesn't pertain to this conversation, so.
No, it does
um,
not.
So we should just move forward with the parameters that we have to work with.
I think you should give the applicant an opportunity to make any further statements that they would like to make, and then ask if there's any public comment. Thank you.
Well, thank you, gentlemen. I've stated my case. I mean, I'm looking to put a driveway up to a rear lot. And I'm 25 feet short. 'Cause if I had 75 feet, there wouldn't be an issue here.
Well, it actually would still be because you would still need to get, you would still need to subdivide the property and the subdivision would have to go to planning.
Right, and I was told in planning or in zoning that if I had 75 feet, there wouldn't be a problem. So it comes down to go see my brother. He give me 25 feet or sell me 25 feet. So I have 75 foot of frontage. That's what the zone calls for.
Probably okay. Then
That
you can
would
do
be a
it.
closed deal.
Yeah.
I'm looking for a variance of 25 feet because I don't have the 20, right?
The staff commenting, so probably at the time when we first saw the request and looked at the plans, that may have been our understanding. But then we just did further research and digging to make sure that we have proper response to this. And that's where we found other information in terms of subdivision and rear lot requirements. And the rear lots, the way that they're defined, there's really no way to kind of look at this
Okay.
otherwise, so.
So I guess my question is to you or the attorney, if they had the 75 feet, that doesn't guarantee them building a house in the back, correct? Because that still doesn't go through us. They would go to planning for that,
That's
correct?
correct, seeking a special permit. And from further review that we've done up to this point, that's our conclusion that it would still be considered as a rear lot, which is prohibited in that zone. Planning and zoning would have to look at it as that.
Oof. Put an addition on.
Okay.
Okay.
Hunter, Christine, any other comments or questions?
No, I mean, I think we've gone a little too far on this, because it's not part of our purview.
Oh, no further questions?
Try to help out, but, okay.
Staff?
Further comments from staff?
Are there any comments opposed or in favor of the applicant, online or present?
There aren't any other participants.
Nobody's else online? Do you want to come up? You have to come up,
come to
sign
the mic,
in,
please.
and well, you can come up.
You're a
sign in.
citizen, and this is audience of citizens, so this is the open part of the hearing.
Come on up. You can sign in and ask your question.
If well,
I
well,
think
that
that's up for you to decide.
that's that if you're commenting as a member of the public, it's your choice whether or not you want to comment. You do not speak on behalf of the Planning and Zoning Commission, and if you do face an application before the Planning and Zoning Commission concerning this matter, you will have to consider whether or not you need to recuse yourself.
That's fair enough.
My name is Tim Zigmont. I've been on the Planning and Zoning Commission probably total over 20 years, 25 years, with Tony actually too. Uh, This lot is not a back lot per se. It is property that has frontage on Lower Lane. It has 50 foot of frontage on Lower Lane. 25 feet of frontage on Lower Lane. Okay. Which he can take off his property that he owns another 25 feet, giving it 50 foot of frontage on Lower Lane, making it a frontage lot on Lower Lane. Okay. That's why he's asking for the waiver of 25 feet, which in your zoning regulations says you can do under certain situations. Okay. This lot back there could be subdivided into 4 or 5 lots under R11 zone. Okay, they don't want to do that. They want to put their single family home and sell their house to the children, have a little home estate there. That's where the Voltzes lived all my life and all their parents' life and everything else. That's the land they own. It's all the way back to the Berlin High School. And I would look into the zoning the lines on the back of Berlin High School with this property because they've changed a lot, which shouldn't have been changed. I know the property very good. But what's before you today as a ZBA is bringing the frontage of this one lot to 50 feet. Okay, which you're allowed under your zoning to do because it's a frontage lot. You're calling it a back lot. If you want to say only one house can be built on it because you gave frontage, that's fine because that's what they want to do. Okay. And I understand I don't understand the planning and zoning is part of it. I do understand that too. But that's not what's presented to you today. And that's why I wanted to bring that point up. Okay, I know that now if it comes to planning, I have to sit back. I can't say nothing now because I made my piece here. You have any questions to me, I would let you please ask me. Because the property in 4 times, 5 times the zone is useless. Not putting a house out there. And it's useless to his house right now. He wants to make it his homestead. How does he do that? That's the question is. And it can be by you waiving the 75 foot, the 50 foot, which your zoning regulations say. There's a thing in the R11 saying that you can do that.
We can't do that.
So that's the question. It really is. And I don't know what else to say because it's concerning this one lot.
There is no lot, Mr. Zigmund. There is no lot yet to grant the variance to.
Do that. We're not allowed to do that.
The lot has 125 feet of footage, and it would be a conditional variance in case the lot was ever subdivided, and that just doesn't make sense to me.
So you're telling me that the property behind his house doesn't have a lot number?
Well, there was something on the schedule that we got.
It's not.
I thought it was.
Have a lot number.
Yeah, it is the one big parcel for 4 or 6 acres.
The house was put in 125 foot frontage, a piece of frontage lot.
Yeah.
And granted that house on that piece of property that it's on right now. Okay. So there should be a lot number on the piece beside it. Because it should have been A or B or C or D, whatever.
This isn't even the official, this is their drawing, right? This is
That's the proposed, yeah.
this is the proposal.
Here I have on the screen,
This isn't even relevant.
I believe this was 1996. The lot line revision done. And it shows, so here there's an indication of a land hook, which means that you merge two different properties together. And this property here gave them 62,000 square feet of land to add to lot 77A. So you see here, size of parcel added to lot 77A does not indicate separate lot being created here. The deed also references that.
So the lot in the back doesn't have a lot number.
So this parcel of land was granted to lot 77A.
You didn't take care of that.
77. It's lot
77A is 363 Lower Lane.
77.
That's his house.
His lot is 77A. What's lot number?
Lot to the left. That's this bigger lot here that used to have encompass all of this land. We have those other maps showing that prior to this.
Sounds like a lot numbers didn't show up here.
No, they didn't subdivide the land.
They never subdivided it.
I'll show you the original land. Was this. And lot 77 is directly to the left of this property. So they owned, I'll zoom in more. Yeah. They owned this portion of land that had been granted to lot 77A. And I go back to the prior plan I showed. So just referencing notes that we see all the time on surveys and maps that are provided to us. You can see indications that the surveyor noted iron pin to be set and moved different locations. This indication here, the zigzag line looks like a Z, is called a land hook. And that usually indicates the merger of another piece of land to a property identified here as lot 77A. So if they were creating a separate lot, it would say, wouldn't say this size of parcel added to lot 77A. It would say square footage of land now indicated as lot, 77A, B, or A2 or something like that.
Yeah, that makes sense.
The zigzag means that they should be merged together. I understand that. But there's a lot pin on every corner of that lot. So
I think they drew over the original subdivision plan, so I'll go back to that image here. They just drew over this plan. I already had those images, indications there. So those weren't new additions.
They were there.
They were there already on that map they used, so they just referenced the original subdivision map. The deed also references parcel of land added to lot 77A, so.
in the legal description. On 77A, 200 by 100 by 200 by 100 foot frontage. So that's the square.
Yep. We see that here in the plan.
That's the square. That's what the legal description of the property is in the town hall.
That's what was submitted on the land records, but if there's a cloud in the title and description, that's something that has to be handled legally by.
That's what I'm asking. How, there's something that wasn't filed.
Yeah, that was on.
This lot was taken out of that big pot lot in the back in 19.
The town clerk's office just accepts documents that are submitted to them. But there's a chance for applicants and
That's not
property
under our
owners to file their
jurisdiction.
title. Yeah, but
That's not under our jurisdiction.
What, if this is what the property says here in the legal records at the town hall, okay. Why wasn't the remedy discussed with the applicant of saying, wait a minute, something's wrong here because it says you 62 acres on your 100 by 200 by 100. That's not 62 acres.
62,000 square feet.
So there should have been a remedy before it came here.
62 acres. Where are you getting 62 acres?
62 acres.
62 acres. What are
Square-
you talking about?
2,000
square feet. Square feet.
Yeah, 60, yeah, okay. All right. Sorry about that.
So that, this piece was taken out. Dated June 24th, 1984 was the original file.
We're getting off track here.
2/15/22.
Yeah. I'm just commenting just for the board to get understanding. But
So, you know, I see the applicant being very dumbfounded here, saying, wait a minute, my house only got 100 by 200 lot. You know, this other lot is my property, but it's the lot. And how can I use that property? Okay, so if he gives, I'm just now thinking on top of my head, okay? I'm thinking, okay, I got 50, I could make 50 foot of frontage here. I could put a road in back there and put 4 or 5 houses back there. I could make some money and then I'll go build a house somewhere else in town.
But
But that's,
But doesn't that come down to, I can give you a driveway, but if planning and zoning doesn't approve subdividing the property, it defeats the whole purpose, doesn't it?
well,
Because us saying you can build your driveway, we can't approve.
somehow the side of the property was subdivided on paper.
Please do not talk over each other. I think the chair had the floor. Let him
Correct, Hunter?
let him
No,
comment.
no worries. I'm just at a point, and again, since I've been a part of this board and everyone else has been on it for decades, you know, for us is about serving the town in all capacities. And I understand the applicants, you know, hardship and their desire of living there with their family and having family around. Just, you know, like I grew up in Hartford. But I think at the end of the day, though, what we're here for, I mean, no pun intended, doesn't give them the end of the driveway, because what they're trying to build isn't up to us. Again, we can give you a driveway, but we can't subdivide the lot to build a separate structure.
Probably true. Maybe once you give them driveway.
Because, I mean, we've
Planning and tell planning what to do.
Right, and I think we're putting the horse before the cart here too, because we can get, like I said, we can give you a driveway, but that's got to go to planning and zoning to subdivide a lot that's clearly shown as just one parcel of land and not subdivided.
You can't, you only get one split on a lot. Okay, this was split, big piece was split from another lot next door, this brother's. And then his piece was split out of the big lot.
But according to town records, it's only one lot.
staff had a comment. So here on that larger plan, which shows that piece of land added to this lot, it clearly indicates here, proof for recording, not a subdivision, a re-subdivision. So there was no lot created at this point.
Okay.
This is indicated by the surveyors, engineers that submitted this plan.
We, like I said, I'm still saying, we don't have the authority to do anything with this.
He built his home on, is not what he thought it was. He thought it was 100 by 200 lot. It's not what he thought it was. I think the applicant should be at least advised what the procedure is from here of getting this property correct. Is it
Planning and zoning.
Planning and zoning. I mean, I think that's been explained pretty well, and I think, you know, we don't have the authority to do that. I mean, that's clear from the law. Like, we can't circumvent the law when it comes to subdivision. That's why the attorney is here, based on the law. There's nothing we can do about it. We can, you know, you can go to planning and zoning, you know, get approval for subdivision, come back to us, and you need the 25 feet, then that's a different story altogether, because there's a path to the end of that driveway. But at this moment, us, you know, giving a variance for something that we have no jurisdiction over, unfortunately, is just.
I understand where you're coming from, I really do.
And I listen, I've been on this board for 2.5 years, and like I see everyone come in and I want to help everybody. I want everyone to be happy in this town.
I've seen this stuff coming for 25 years. I've seen the same stuff all the time. But you have a deed filed in the town that says this is what you own for your house. And if he sells this to his brother, that's what the brothers go know too. That's what he owns, 200 by 100. Right? Because here's the legal description. You know,
But again, it comes down to the subdivision part more than it comes down to anything else, because that's the basis of it is the subdivision.
but he was.
They're not doing a driveway for a shed in the back. They're doing a driveway because they want to have 2 different addresses at that point.
It's recommended to come here, and maybe that's one step too fast to come here. This has not been a short time because he brought this into my attention a long time.
Of course.
Okay.
And
guess
I would,
it was coming to planning first, I guess.
and I think that's I think that's the best route, and I think that's the best way to address this. And I think it would be, the best way to do it, because if planning and zoning then approves a subdivision, then it's got to come to us for the variance, correct? Would that be I'm not trying to speak ahead.
Again, the problem.
Again, there's conversation about whether or not this is a subdivision, okay? That has a very specific legal meaning. And this is running so far afoul of what this board is here to do tonight, okay? He was told to come here. That's the representation that's being made by the current speaker, Mr. Zigmont. But staff's report indicates there was a back and forth about the issue with the rear lot. Then very clearly, it appears that the request was changed. We have to deal with the current request. We have to deal with what the representation was made, or the board has to deal, because I am not a vote. Not a vote. And I give advice based upon the law. It's your decision whether or not you follow the advice. Okay? But the law is the law. And you have an applicant before you expressing what their intention is. You've looked at the map, okay? This is one lot. I don't think you have anything before you, and I'm looking right now at the deed. It indicates, and this is the deed that's going into your applicants tonight, Mr. and Mrs. Voles from Jenny Voles. And it indicates revised 2-2. It's mentioning the subdivision plan property of Jenny Voles, Jenny S. Voles, Lower Lane, Berlin, Connecticut, dated June 24th, 1984, revised 2296 to show parcel added to lot 77-A, scale 1 inch equals 40 feet, drawn by U Engineering, PC, Berlin, Connecticut. That's the map that's referenced in the deed into them.
The advice is where to go. This is easy. This back lot thing happened after the transfer here. So I don't know if the back lot still, I don't know if back lots are in play, but it can be. I don't remember when we did the no back lot thing. I don't know where to.
Well, we didn't do the no backlot thing. You guys did it.
It helped us.
So I don't, I don't know what to tell you.
Now, but.
I think it's a
Are there any other comments in favor or opposed?
Did you want to say something additional?
Tony?
I don't have anything else to say.
Corey?
No.
Hunter? Christine?
No.
Staff?
No comments from staff.
I was just waiting for Christine, sorry.
No.
Thank you. Well, I'll ask for a motion to close this.
I'll give that motion.
I'll second it.
All those in favor?
Aye.
Aye.
Okay, and we'll close that and then we'll conduct our old business. ZBA 2026-11, 6 Sawmill Drive, map 21-4, block 118, lot 5. William and Sons Building, represented by William Hesback, is requesting a variance of the Town of Berlin zoning regulation V.A.10 to allow a 26 feet by 24 feet home addition to be located 26 feet from the property line where 40 feet is required and 18 feet from the side yard where 25 feet is required in an R21 zone. The property is owned by Theodore A. Jr. Kaplan and Armin R. Kaplan.
I'll make a motion to approve the application.
I'll second that.
I have discussion.
Yeah, I was going to say, I think we have to have a discussion first.
I think we need to amend the motion to be approval, subject to the owner's plans to show the breezeway.
Oh, that was a different application.
Oh, I'm sorry, that is the next one.
This one's attached.
I withdraw my comment.
I believe you have to do the motion stating reason you're granting in favor or against.
You need a statement of hardship pursuant to the statute and your regulations. Remember, you're looking at section A2 of your regulations and also B5, which contains your specific findings. But you do B5 and then B6 also reiterates the requirement to state the specific hardship upon which decision is based if you grant variance. And you should be deciding upon collective reasons. That's the law. It's in the statute.
Like me to pull up the plan again for the property?
Yeah, this is the, I don't have a problem with it. The existing garage is getting demolished. It encroaches further into the setback than the current proposal.
That was the front one.
Yeah.
Yep.
It's in a
Got
corner
there,
lot.
Right there on the screen, I have that now. So this.
Yep, that was.
circle
Yeah,
ahead.
he's on a corner, so I don't have an issue with that.
And what was the variance from the amendment, I should say, from last month's hearing?
So the original
Do we have to
application,
bring it back?
the original application only included the front yard setback,
Not the site.
then not
Okay.
not the side yard. So they amended it to
Yeah.
include that side yard
Gotcha.
setback.
Yeah,
Okay.
that wasn't.
Yeah.
A big deal. Not be any further discussion. Okay, I'll make a motion, I'll repeat my motion to approve the application.
What was it? You made a statement too of,
I mean, if there's no further discussion, I'll make a motion to approve the application.
you want to include, I believe you made a statement regarding the decrease of nonconformity. They're eliminating the
Oh,
garage.
no, when I read the application, the old garage was more non-conforming than the new one.
Mm.
So I really didn't see any issue with it. And so, I mean, but we discussed that. And
My-
I'm
my
just gonna
question today-
repeat my application, my motion to approve the application. As long as there's no further discussion.
My thought is it based off of that statement you just made,
Yeah.
an acceptable motion, right, Attorney Capola?
Well, it is essentially, it's the exception to the hardship is what
Mhm.
the Adolphson exception, so that's the finding of the board.
I second the motion.
Do you want me to read the hardship analysis?
Sure. I think, yeah.
The applicant indicates that the lot shape, grade, and setbacks from neighboring properties presents challenges for this project. The existing garage, which is getting demolished, encroaches further into the setback than the current proposal. So we're probably better off with the new one than we are with the old one.
So you can make a
Okay,
motion based off
and-
of that.
Staff has identified changes in grade as shown in the plan provided, as well as the presence of a water course in the rear of the lot and non-encroachment line within the inland wetlands. So, I figured it's probably okay.
So your motion could be based off of those conditions that you agree with and have.
Oh, yeah,
like
yeah,
right there.
that's what,
We have a motion and a second, so let's vote on this.
All those in favor?
Aye.
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 Okay. Oh, Hunter. Hunter?
I had said aye at the same time as somebody else.
Oh, okay,
Aye. Motion passed.
okay.
ZBA 2026-12, 41 Primrose Lane, map 9-3, block 54, lot 37E. Andrew J. Fowl is requesting a variance of the Town of Berlin zoning regulation, B.A.10. To allow an expansion of a screened porch within the side yard setback and a front deck porch addition to be located within the front yard setback as shown on the submitted plan. Where side yard setback of 10 feet is required and a front yard setback of 35 feet is required in an R15 zone. Discussion? Corey?
No.
I'm good.
Any discussion, Hunter and Christine?
No discussion from me.
No, I'm all set. I make a motion, we approve this application.
Anything from staff?
Just again to take the reasoning or the findings from the board. That motion.
Christine?
No, I'm all set.
No, your reasoning for the motion for approval?
Again, I feel that this is micromanaging. I feel that this is, I feel this is micromanaging.
Would we like to reference the narrative from the applicant?
Yes, please.
fight that continued into the Cold War and South Korea back.
This is
the North Korea actually almost faded Soviet Union. Throughout this time, the North prioritized government spending on
this is a little bit flowery. I mean,
Do you want me to read the,
Have that document?
yes, the narrative for the addition to the home? In considering adding a room to connect a seamless addition to the 3-car garage, there are many considerations. Firstly, the room had to be large and have many windows to let light in. Entrance to the room will be through a door that will allow wheelchair access, and this room will allow elderly family members to enter and exist easily. It will hopefully blend to the house. The room will be in effect, a quiet, climate-controlled sanctuary sunroom with wide open windows that would allow late afternoon light. One door will allow access to the existing home where there is now a window. Another door would lead to the garage. The front of the house will be improved by adding a porch from the front door to the right side of the house, wrapping around a little bit to meet the level sidewalk with no need of stairs. The window from the lower level will be covered by the porch, as there are really no function, there's no functional or attractive. There will be no need for stairs going to the left of the house where there was a driveway a long time ago. Now the driveway is on the right side of the house, so the stairs will not look like they are going down the wrong side. The existing garage that is not at all level with the home will be demolished, and a 3-car garage with the bedrooms above will be built slightly back and on level ground. The south side screen porch will be extended slightly as to be flush with the back of the house. With the addition, it is hopeful that many issues will be addressed and taken care of. Thank you for your time and consideration.
We have multiple projects going on, and the footprint that we are only addressing the porch, correct, on the side, that is just being made larger. And then the stairs that are already there, the footprint is already there. It is simply being a deck being added on top of where those stairs are already in existence, correct? This whole garage and everything.
Yeah, yes, the garage is not of issue. That
Correct.
is
It's
correct.
nothing to do with what we are looking at. It is simply the 2 small areas on the front and the left of the house that we are concerned with. And this is already almost, if you're looking down at it, within the footprint of what the area that is, it needs the variance for is almost within the footprint with what is there, existing. You know, he's making that existing screen porch larger. And then you see the stairs that are there, the deck that he's putting, scooping around. It's already going over stairs that exist to enter the property. So that's why I feel we are micromanaging. I feel it's already kind of within the footprint that is there. That's what I meant.
okay.
So she made a motion in favor?
I'll second a motion. Assuming no further discussion,
Yeah, is there any further discussion from you, Corey? Staff?
No further comments from staff.
All those in favor?
Aye. Aye.
Aye.
Aye, motion passed. ZBA 2026-13, 30 Linden Drive, map 26-1, block 74, lot 200. Alan and Rhiannon Solek are requesting a variance of the Town of Berlin zoning regulation VIII.I to allow a 28 feet by 36 feet garage addition to be located 22.5 feet from the side yard, where 45 feet is required in the MR1- zone. Discussion.
The only thing that I would say with that would be that, what Corey mentioned.
Oh, the
before, that,
breezeway.
The conditional approval would be, granted, with the inclusion of a breezeway plan to connect to the house.
Okay, on the plans to be revised, the plan submitted to the building department, construction to be revised to show a breezeway.
Well, if that's the way you want to do it, that's fine. I guess I guess I don't want to put a hardship on anybody, but I mean, it's one of the things that we talked about was that we're connected to the house.
Mm-hmm.
And, in order to connect to the house, the 4x7 breezeway area, or when you call it mudroom or whatever you want to call it.
Yeah, that's required.
If you want to include it on the plans, I mean, if that's one way to do it, that's fine.
Yeah. So with that motion, you're agreeing then with the applicant statement of the hardship that they have to.
Yes.
Significant hardships based on the characteristics of the property.
Yeah.
Especially including the wetlands designation,
Is it pretty wet back there or what?
designated as wetlands all around.
Did our inland wetland people? Look
They
at this?
designated my sidewalk as wetlands one time.
Did our inland wetland people look at this? When I look at that map where they have that highlighted green area,
Yeah, we're not on that. We're not encroaching it.
I guess
Yeah,
it's
so the plan did
it
indicate.
looks very
I did
close
speak-
on this map here. It looks, very close to that shaded green area, It looks like you could, dive into a swamp from here, but maybe it,
So at least I'll show that plan once more.
yeah, I don't know. I mean, as
I
long
did
as there's no environmental implications there and that's okay, then this would be okay with, I would be okay with the stipulation of the breezeway.
Yep, so I did speak with staff for inland wetlands. And it was indicated here, I think they missed it originally on the plan and they highlighted it, but that proposed plan when they built a home did show that they were gonna fill in that area immediately near where the garage is proposed, so.
Right.
That's not something of concern for this.
Okay.
Okay. It just looks so close in the picture,
Motion made, I second.
All those in favor?
Aye.
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 Motion passed.
Okay.
ZBA 2026-14, 224 Berlin Turnpike, map 4-4, block 82, lot 18-7715. Rana, not going to pronounce the last name, sorry, is requesting an alcohol use location approval for a grocery beer liquor permit. The property is owned by 224 Berlin Turnpike LLC and is located in the PS-B zone. And we also, I don't think we brought it up, and I'll bring this up in discussion. We had a letter from Mr. Orsini just stating, his hopes that it gets approved, being he is the owner of that whole area, for crying out loud. So
A little squirt.
what?
A little squirt.
Sounds a lot.
Yeah. 11 dealerships.
Motion to approve the application.
And with and
Was that a motion to approve?
Yes, Commissioner.
I'll make a motion
Whiteside
to
made a
approve it.
and then this
Location approval.
So the
Second? Is that a motion? I'm having a hard time hearing.
sorry, Christine, I was just about to ask staff a comment, a question. So with this approval, we're just approving beer? Is that so? Because she still has to go through the state for a permit.
Yeah.
Yeah, that's correct.
Okay.
That's just location approval.
Okay.
It's approving staff to sign off on the state
Okay.
application.
I still don't know why we do that. So.
Okay. Yeah.
And staff report does indicate that there are no other grocery beer permits located within 1,500 feet of this location as well.
Yeah.
Christine, did you make a motion to approve?
No, Commissioner White's,
Oh,
Make a
Corey
motion
did.
to
Corey.
approve. I
All
would
those,
like an opportunity to every small grocery store to compete with the one, large grocery store we have in town. So yes, I make a motion to approve.
all those in favor?
Aye.
I,
It's approved.
Aye.
Thank you, Christine and Hunter. Minutes?
Oh, the last,
Oh, we do? Oh, that's right. Sorry.
Lower Lane.
ZBA 2026-15, 363 Lower Lane, map 15-2, block 102, lot 77A. Arthur and Cheryl Volts are requesting a variance of the Town of Berlin zoning regulation V.B.5 to allow a subdivision and the building lot to be created with frontage and width of 50 feet from their existing property where 75 feet is required in the R11 zone.
Motion to deny this application based on the jurisdictional aspects we discussed with Attorney Capola.
I'll second that.
All those in favor?
Aye.
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 Motion is denied. Good luck with the state. Approval of minutes?
don't give up, and I hope you continue to look for ways to utilize the land, and, I hope you don't look upon us that we don't want you to find a way to use the land, because we do. We do, as a board, we do.
White is here.
Thank you, Christine. Approval of minutes?
May. You sent out May, April, and June, or April, May, June.
Because we didn't approve last month, correct?
No, we didn't.
I don't think we,
I only got June.
I thought, yeah.
Yeah, no.
Only June should have went out.
Yeah, it should just be June that we're approving. We
Did approve
approved.
April and May?
Yeah, we did.
Oh, okay, all right.
Yeah, we did.
We're caught up.
Yeah, we
I
are
didn't
caught
realize-
up.
I didn't realize we were caught up. Oh, that's good.
Motion to approve the June minutes.
All those in favor? Oh, wait, sorry, second.
I'll second.
He was saying, and I was jumping ahead.
Yeah, I'll second it. And,
All those in favor?
Aye.
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 So I got all 3 months. Okay, good.
Yes.
All right. Oh. Shut the mic on.
Motion to.
Well, we were waiting for Christine. Can I ask for a motion to adjourn?
Motion to adjourn the meeting.
Second, aye.
All those in favor?
Aye.
Aye.
9:07 PM. Thank you.
You can shut the mic off now. That guy will drive